Judgment in the appeal, Sharland and Sharland.
Mr. and Mrs. Sharland are getting divorced. They were married in 1993 and have 3 children, one of whom will require care throughout his life. They cannot agree about the distribution of their substantial assets. In particular, Mr. Sharland has a large shareholding in a successful software business, and they disagree about how this should be valued and divided between them. Their respective experts valued it on the basis that there were no plans to offer the shares to the public. At the trial, Mr. Sharland gave evidence that there were no such plans. The parties reached an agreement during the trial, which was then embodied in a consent order which the judge approved, although it was not, in fact, finalised by sealing. It soon emerged that the husband's evidence was untrue. There were active plans to sell the company, which was likely to raise far more than either of the expert valuers had thought. Mrs. Sharland asked the judge not to seal the consent order, while Mr. Sharland asked him to do so. The judge held that Mr. Sharland's evidence at trial had been dishonest. Had he given truthful evidence, the judge would have made a different order. He would have adjourned the case to see whether a sale did indeed take place. Nevertheless, as things had turned out in the months since then, there had been no sale, and so he would now have made the same order as he had made then. So he concluded that the order should be finalised. Mrs. Sharland appealed to the Court of Appeal, which dismissed her appeal. The majority held that in matrimonial proceedings, unlike ordinary civil proceedings, the order made by consent derives its authority from the court and not from the party's consent. Hence, if the court would now have made the same order, the non-disclosure could not be material. Lord Justice Briggs dissented on the ground that fraud unravels all. It vitiated the wife's consent to the order. Mrs. Sharland now appeals to this court, which unanimously allows her appeal. In matrimonial finance proceedings, the court has a statutory duty to decide what the right order should be, bearing in mind the criteria set out in the Matrimonial Causes Act 1973. So that the court can perform this duty, the parties each have a duty to make full and frank disclosure of their affairs to one another and to the court. The court may approve an order agreed between the parties, but, as the Court of Appeal rightly said, the order derives its authority from the court and not from their agreement. Nevertheless, it must be a valid agreement. Mrs. Sharland's consent to the order was vitiated by her husband's fraud. By the husband's fraud and the judge's order, she had been deprived of her right to a full and fair hearing of her claims. Furthermore, what mattered was what order the court would have made at the time and not what order it might make now. The appeal is therefore allowed, and the case must return to the family division for further directions to be given as to how her claim is to proceed.